Welcome to the Legacy Cast by Kelley Legacy Law.
Hello and welcome to the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. Their practice focuses on helping families enhance their lives today and secure their futures tomorrow. I am your host, Kevin Rosenquist. Today we're going to talk about probate. We're going to kind of talk about some myths versus reality and just overall probate and estate planning in Alabama. So Michael, welcome back.
Thanks, Kevin. Good to be back.
All right, so I think we touched on this a little bit on the first episode, but just in case, let's do a little bit of a rehash here. What exactly is probate?
Yeah, probate is the legal process by which someone's assets that they're holding in their individual name when they die, it passes through the court system to get to their heirs. So if you die without a will, typically it's going to be your next of kin. If you die with a will, then it's the people that you've named in the will to receive things. So I call it a lawsuit that you file against yourself for the benefit of your creditors, jokingly, because probate is not necessary for everyone, but it is a good thing, for your creditors to have for themselves so that they can bring claims in a nice open lawsuit there for you in the probate court.
What are some of the most common misconceptions that you find people have about probate and estate planning? Well, let's just stick to probate mainly in Alabama, because you hear that word a lot, and a lot of people don't understand what it is or how it works. What do you see as the biggest misconception?
Yeah, it's kind of funny. I think most people have this idea, and it comes from movies, right, where when somebody dies, there's going to be a reading of the will where we all get together in the family study, right?
Around a fireplace.
Yes. And we're going to sit in the big leather chairs, and the attorney is going to read the will, maybe play a video from dad, how he's leaving things, and everybody's going to fight and get upset. But when it's over, I guess the lawyer's just going to write checks to all of us, and that's it. Because in the movie, that's where the scene ends, right? It never goes over to the courthouse and shows the next, 12 to 18 months before anybody actually gets anything. So,
well, that's not good TV. Come on now.
But unfortunately, I think that's where we get our ideas about what happens when somebody dies. So, most people it's almost like probate is a necessary thing like death and taxes. Well, I guess that's just what happens. You do a will and nobody really knows anything beyond that. So I think the biggest misconceptions are, number one, that it's a legal process, really. Number two, that it's a requirement, seemingly, to just go through it. And certainly, there are misconceptions about what the process itself is.
If you don't mind, I'd love to ask some questions about what kind of things, how some certain aspects of a person's life or whatever affect probate. So like, for example, someone gifts a home to their children before they pass away. How does that affect probate? Are there any risks or unintended consequences with that?
There are things that people do because they feel like, they're being smart, they're being savvy to avoid probate, and boy, they can really be costly. I'll give you an example. We're talking about deeding a house to a child before you die. I have a recent client whose father, bought at a very, very cheap price some land on a very nice lake here in Alabama back in the 1950s when there was nobody there. That lake today is extremely popular, and those lots are probably worth about $5 million. All right. Well, before he died, he went ahead and deeded those lots over to his children, thinking, okay, I'm helping because we're going to avoid probate now. But what he didn't realize is that he gave a gift to those children by deeding it before he died, and he also gifted his cost basis in those lots to them for capital gains tax purposes. So now his children, if they want to sell those lots, they're going to be paying 20% of the difference between basically $0 and $5 million, the basis when the father acquired them versus what they're worth now. So, they've got that cost basis, and really they feel like they can't sell those lots because they don't want to take that major tax hit. So that's the big problem with deeding it directly to a child. Of course, if you're still living, you lose total control as well when you just deed it to someone else and your name's not on anymore. Other things people will do, though, is they'll say, well, let me add the child onto the deed with me while I'm alive, and we'll give them rights of survivorship. We'll own this jointly. So when I die, it automatically becomes theirs. Okay. Well, when you do that, would you avoid probate? Yes. But, what happens if that child has a judgment creditor out there? or, something happens, now they're on the deed with you, your property could be in jeopardy or something like that. And also there's a question of whether or not adding a child on there is a gift or not. That's kind of a CPA question. Okay. But it still could be considered a gift that could trigger capital gains tax. People try to avoid probate in different ways. Always need to get the advice of a CPA and an estate planning attorney before you go doing something like that, to make sure that all your bases are covered and you're not making an inadvertent mistake.
Yeah, it sounds like perhaps they might have gotten some bad legal advice.
Or none at all.
Or none at all.
You know what I mean?
Yeah, no doubt. Well, so in that situation, like you just named, what should they have done?
It depends on the state that you're in. In Alabama, there's really two ways to pass real estate like that outside of probate. Number one, you can do what's called a life estate deed, where let's say you're an older person, maybe you're a widow or widower, you've got, 2 adult children, you don't have much else, maybe you've got a couple of bank accounts, so not a big estate. You're getting up in age, maybe you want to go ahead and deed the property to your kids, but reserve a life estate in that property, which says you get to live there for the rest of your life. And when you die, the property automatically reverts to your children and it's theirs. Now, that solves your capital gains tax problem because there's a step up in basis when you die. But, you still have an issue with people being on the deed with you. So if you decide you want to sell it, you have to get your kids' permission, and vice versa. They'd have to get your permission if they wanted to sell it. The other way, to avoid probate is with a revocable living trust, where you can create this trust while you're alive, transfer the deed of the house over to the trust so that when you die, you don't own anything that has to go through probate, and your successor trustee just takes over and can then manage the property and get it where you want it to go. Now, some states like Florida, for example, have things called ladybird deeds, where it's like a transfer on death deed, where you can almost like leaving a beneficiary designation on a life insurance policy or something. When you die, that deed can go ahead and pass to those people without probate. And then some states have something very, very similar, but slightly different. It's called a transfer on death deed, where you can, again, name the people that you want to receive it, and it can pass around probate that way. Some states like Alabama don't have that yet, so we're still dealing with either probating, real estate, or passing it through a trust.
Yeah. Speaking of trusts, can you talk about a living trust and does that avoid probate?
Well, a fully funded living trust does, yes.
Okay.
So, like I said earlier, you've got some assets I call probatable assets. When you die, if they're in your name as an individual, then they're going to have to go through the probate court. So if you've got real estate or bank accounts, brokerage accounts, some people even on their life insurance will name the estate as their beneficiary. Or let's say you've got outdated beneficiaries. Maybe it was left to somebody who's now died. The default is going to be for that to go to your estate. Okay. So assets can end up in your estate in many different ways. To avoid that, you've got to make sure that you've looked at all of your assets, you've inventoried all of your assets. So you know what you have, where it is, and who's supposed to receive it. And if you have a revocable living trust, make sure that you have retitled those assets so that they either are owned by the trust while you're alive, or that your trust is a beneficiary of those assets to receive them after you die. So your trustee could then contact the life insurance company or, the financial advisor and say, hey, I'm the successor trustee of this account. I've now got control of these assets. So, yeah, it takes, some inventorying and some monitoring over time to make sure that trust is fully funded.
Mm-hmm. Yeah, I've heard of that before, actually, where people have a trust with nothing in it.
There's a lot of them out there.
Yeah.
And they're worth the paper that they're printed on.
Yeah, that's so. Do people just forget? Do they just think, oh, I'll fill it later and not do it? That's just so. That seems crazy to me to start a trust and not put anything in it.
I have no way. I'm not going to assume anything, but you have to wonder sometimes what kind of legal advice they got. Did they buy a document? There are attorneys out there that are transactional in nature, and they will do a trust for you and they'll send you home with it. But did they tell you that it has to be funded? Did they explain to you how to do it? So it really matters what kind of counsel you got. But, I tell people it is kind of like getting an 8th grader to do their homework. You have to stay with people after they sign their documents and say, okay, let's be aggressive and let's try to get this done in 30 days and kind of monitor it along with them to see if they've gotten it done.
I like that. 8th grader doing their homework. I like that. That's a good analogy.
That's the way it is.
I believe it. I don't have an 8th grader yet. Eventually I will. But I remember myself in 8th grade did not do my homework very well on my own anyway. For someone who hasn't done any estate planning at all, might be listening to this podcast, what are the first steps they should take to ensure their assets pass smoothly to their heirs?
Of course, they can do research online. They can certainly go to my website, KelleyLegacyLaw.com, and learn a lot about the things they need to be thinking about. There's tons of resources out there now. Some things can get really confusing. If you go start researching about trust, then boy, there's all kinds of trust. We're talking about revocable living trust, but you've got all kinds of irrevocable trust and things that you can do that are really more advanced for high net worth individuals. But first of all, just do a little basic research, but then, really sit down and think about the assets that you have and, inventory those. Sit down and think about who would I want to receive these things? Who would I not want to receive these things? And just take the time to consider those things. And then, watch podcasts like this. I mean, YouTube is a fount of information. There are lots of attorneys that are really good attorneys that are giving good information, educational information out there. And then like what I do myself, I do webinars that I, advertise locally, and I do in-person seminars. So, those are free. Nobody has to pay for that information. Get to come and watch a webinar or come to a live event, meet me and ask questions. So, there are tons of resources out there for people who are genuinely, seeking to, take on this estate planning and get it done.
Another question I wanted to ask you was about, certain assets, because I think you would call them not probatable, but probate is something like that. I can't remember, but Are there assets that automatically bypass probate?
There are if you've got them structured properly. So, let's talk about a married couple. All right. So let's say most married couples own their home as joint tenants with rights of survivorship. So that means when one person dies, the other one automatically owns it. There's no probate for that. Now, what happens when the second person dies, that's a different story. That might actually be going into probate. But, joint bank accounts, if both of you are on there jointly. For bank accounts, you can actually do what's called a payable on death or transfer on death designation form, where you can name beneficiaries. So when you die, they can claim that money from the bank directly. So it doesn't have to go through probate. Your IRAs, your retirement accounts, those would have beneficiary designations. Your life insurance would have beneficiary designations. So there are plenty of things out there, and there are ways to avoid probate with them. The question is, do you want to take advantage of some of the things that a revocable living trust could do for you as far as asset protection and tax planning versus, people just receiving things outright when you die? So yes, you can leave beneficiary designations, but do you want that person to receive a lump sum of money the minute you die, or do you want to do some things that maybe protect it from immaturity if they're not ready to handle that kind of money, or a future divorce, or a judgment creditor? So those are all questions that go beyond avoiding probate, but there are definitely things that people need to consider.
Yeah, one of the things that I feel like I keep getting from you, and this is our third episode now, is just having the full picture, having the full plan, and not assuming like, I remember when we got our life insurance and we picked our designation or designators and all that, and we did all that stuff, and that wasn't part of any sort of a will or estate plan or anything like that. So it really is sort of like you've talked about having talking to people when they come into your office, getting a complete picture of their family and goals and assets and all that stuff to put together a complete plan that protects them.
Exactly. Depending on the level of wealth that someone has and what the laws are at that time, you may have a situation where life insurance, could be a problem if you have a trust and it pays in there. Is it going to put you over the inheritance tax limit? Maybe we want to leave our retirement accounts to our spouse primarily, even if we have a trust. So because our spouse will get to stretch out the distributions of that IRA across their entire life expectancy, versus if we leave it to our kids, maybe they won't. Maybe they have to pay all the taxes within 10 years. So there are lots of technical things that we can get into, but as far as having good advice from an estate planning attorney, they need to know all of that about your family and your assets to really be able to give you a full picture. And look, some people are hesitant to want to turn that information over to an attorney. They say, well, I have a financial advisor. Why do you need to know these things? And it's because, in order for us to fully advise you properly, we've got to be able to take your net worth into account and all the different kinds of assets you have to know, okay, if you want to avoid probate, here's some ways you could do it with just a will plan. Here's the way you could do it with a revocable trust. But without knowing that, we really are flying blind on giving good advice.
Yeah. And to your point in another episode, there's no cookie cutter, one size fits all kind of plan. So it's important to have it tailored to exactly what your current situation is or what your family situation is.
Exactly. Yeah. I mean, it's, like you said, we've gotten to a point where there are things you can just print off online. I had one client that just went into the bank and filled out, a one-page form. It ended up being disastrous because people that he may have wanted to disinherit didn't get disinherited. Property that he may have wanted to pass to certain people didn't go to those people.
Wow.
Because we had to guess about a lot of things. And if you do an estate plan, even if you do a will, if it's silent as to certain things, it's going to default to the estate's plan for you, intestacy. So that particular gentleman had listed his personal property and where he wanted it to go, but there was no mention of real estate. Well, he had real estate. So what do we do with it then? Well, if the will is silent on it, which was a little one-page thing he did, then it defaults to intestacy. All right. We ended up, in a will contest and litigation that lasted quite a while. So that's the kind of thing that can happen if you don't get the proper guidance.
Yeah, no doubt. All right. Well, thanks for tuning into the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. To connect with Michael and the team, head to kelleylegacylaw.com. Please like and subscribe to our channel. We love having you be part of our community. Michael, I loved having you here. Thanks so much for the conversation and all the insight.
Absolutely. Thank you so much, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.